Hi everyone, this is Pat Kramer, and I wanted to talk to you about an interesting United States Supreme Court case that came down just about a week ago. The case was called Filarsky v. Delia, and this case raised the question of governmental immunities, and specifically whether those immunities extend to a private citizen who is working for the government in a part-time basis. Now, first we need to answer what's an immunity. Well, under Section 1983, which is one of the primary laws that exist for a private citizen to sue the government if the government has violated one of their rights, under that law, governmental actors have certain immunities, which means either they cannot be sued, or if they have what's called qualified immunity, it means they can only be sued under certain circumstances. And so the question in this case was whether this part-time private attorney could be sued under Section 1983 or whether they would have some kind of immunity. And what happened in this case is actually an interesting case. There was a firefighter in Rialto, California, whose name was Nicholas Delia. And Delia responded to a call, and there was some kind of toxic fumes or something like that on the call, and he got sick. And he was out for about 3 weeks. Well, the fire department got a little suspicious that he was out for so long and for so much time, and so they hired a private investigator to follow him around. The private investigator, in the course of following him around, saw him purchasing apparently a pretty large quantity of building supplies for his home. And of course, immediately, people became suspicious, because if you're well enough to purchase and then purchase building supplies and then fix up your home, well, then you should be well enough to come to work. And so once they did that, or once the private investigator saw Delia buying these supplies, he reported back to the fire department, and the fire department said, okay, we need to bring Mr. Delia in for an interview. And what they did was they hired a guy by the name of Steve Filarsky to conduct this interview. And Filarsky becomes the centerpiece of this entire case, because he's the private employee. He's a private attorney who had some 30 years of experience in employment law, and the city brought him in because he was an expert in these kinds of issues. But he doesn't actually work for the government other than on kind of like this part-time basis. And so what happened was, during the interview, Filarsky was interviewing the firefighter Delia, and Delia's attorney was there. And during the course of this interview, they said that they wanted to see the building supplies, and Delia said, the firefighter said, well, yeah, I bought the building supplies, but I haven't actually done anything. I haven't used them yet. I haven't been well enough to actually fix the house up. So they said, well, okay, well, just show us the building supplies, and because if you haven't used them yet, you ought to be able to show them to us pretty easily. And Delia's attorney objected to that and said, no, that violates the Fourth Amendment, prohibition against search and seizure law. And they said, no, that's nonsense. We want to see the building materials. And what happened then was, ultimately, Delia showed them the building materials, because in fact he actually had not used them yet. And so what happened was, he brought the building materials outside of his house and showed them to Filarsky and I think the fire chief, and then they drove away. They left. Well, Delia then brought a lawsuit under Section 1983 alleging a violation of his Fourth Amendment rights. And ultimately the case worked its way up to the Supreme Court, and the Supreme Court held that Mr. Filarsky, the part-time attorney who had been hired by the city to conduct this investigation, the Supreme Court held that he did have immunity, because one of the lower courts had said, no, Filarsky, he doesn't have immunity because he's not a full-time governmental employee. The United States Supreme Court, I think quite rightly, said, no, that's nonsense. If you are working for the government, even on a part-time basis, and you're conducting some kind of governmental function, or you're doing some kind of internal interview for the government, and you're performing some kind of governmental task like Filarsky clearly was here, then you have immunity. And so what the Supreme Court says, it doesn't depend upon whether or not you're a part-time employee or whether you're a full-time employee. It just depends upon what are you doing for the government. And if the government hires you to perform some kind of task, then you're probably going to have immunity from suit, or at least qualified immunity, which again means that you can only be sued under certain circumstances. And it's a very interesting opinion. It's written by Chief Justice Roberts, and he goes back and does a very interesting historical analysis of the nature of government. And he points out that way back when, at the beginning of the country, it was the case that, and even until the late 19th and into the early 20th century, it was the case that many governmental employees were not full-time governmental employees. In fact, they were private citizens who were performing governmental tasks kind of on the side. And he said in those days, those part-time governmental employees clearly had immunity from lawsuits. So that immunity extends into modern times, and even though Mr. Filarsky was not a full-time governmental employee, he still had immunity. Now, there's something else that's interesting in this case, that's interesting in the opinion, I should say, which is that it's kind of a cautionary tale for attorneys, because what happened during the interview that I described earlier, where the Filarsky demanded to see the building materials, Delia's attorney, the firefighter's attorney, basically threatened lawsuit against the city during that interview. And there's a transcript of that interview, so we know exactly what was said. And the attorney basically threatened, well, not basically, he explicitly threatened to bring a lawsuit against Filarsky, against the investigator. And I got to tell you, I think that Chief Justice Roberts wasn't too pleased with the way that Delia's attorney was acting at this meeting, because he put some of these quotes into the opinion. And I'm going to read just some of what was from the opinion. Delia's attorney said, quote, "We might quite possibly find a way to figure out if we can name you, Mr. Filarsky, as in name you as in the lawsuit. If you want to take that chance, you go right ahead." And then the Chief Justice continues, "The threat was repeated over and over. Quote, everybody is going to get named, and they're going to sweat it out as to whether or not they have individual liability. You order him," in other words, you order the firefighter to produce these materials, "you order him and you will be named, and that is not an idle threat." And then he continues, "Whoever issues that order is going to be named in the lawsuit." And then again, "We will seek any and all damages, including individual liability. We are coming if you order this." And then, "Make sure the spelling is clear in the order so we know who to sue." Now, so those were all the threats that Delia's attorney was making against the city and also against Filarsky, the investigator. And it's not an accident, I don't think, that the Chief Justice put those quotes into this opinion, because I think those kinds of quotes don't sit very well with judges, quite frankly, and of any stripe. And so I'm sure that there's a little bit of embarrassment on the part of Mr. Delia's attorney that those quotes those threats made it into a United States Supreme Court decision. So I think there's kind of a cautionary tale here for attorneys, which is always play nice, because you never know when your quotes are going to end up in a United States Supreme Court opinion. So that's the roundup for Filarsky v. Delia. Governmental immunity applies to even part-time employees of the government who are performing governmental functions. So that's it, and thanks for listening.